So here is another session of Legal Update Special Edition for CLAT. Let's see what do we have today. First one is right to change one's name. This was quite an interesting case that we saw this year. And there were certain articles in the newspaper, and that is why I have put it here for the discussion. So basically, High Court of Allahabad and Delhi, they came up with this unique uh, case wherein the in question was one's right to change the name, right? And according to Allahabad High Court, they considered it to fall within the ambit of right to freedom of speech and expression. And further, it was said that uh, right to freedom of speech and expression can be restricted only on the basis of the grounds that are mentioned under Article 19, Clause 2, right? I guess in the last session also we discussed something about these restrictions mentioned under Article 19, Clause 2. And on the similar lines, the Allahabad High Court stated this. Now, not only is it about Article 90, it was also considered to be covered under Article 21, since it brings up right to life and personal autonomy and liberty as well. Also, there was this case in Delhi High Court, Sadanand versus CBSE, wherein there were two brothers who were allowed to change their surnames on the ground of some caste atrocities issues and social stigma issues. And later on, of course, CBSE raised certain concerns against it. However, at the end, Allahabad High Court also emphasized uh, on the importance of this openness, this freedom to change one's name. But it's just that simultaneous updates have to be done with respect to every identity related documents, right? Now, that is administrative issues. We are not going to get into that, right? Hence, one's right to change their name. Yeah, there are two fundamental rights that are involved, Article 19 and Article 21. Next one is with respect to Press and Registration of Periodical Bill 2023 and Mediation Bill. However, here more sort of discussion was done with respect to mediation. What were these bills about? So basically, these are the new bills that were presented before the parliament this year, wherein certain restrictions were sought to be put on media, right? So as to make those media channels accountable and make the entire process transparent, right? So that was something which was discussed in the first bill, that was the Press and Registration Periodical Bill 2023. Another one was Mediation Bill. Of course, as the name suggests, it was about the mediation. And I'm sure by now you would have learned about alternative dispute resolution, under which mediation is covered, right? What are the other ones? Arbitration and conciliation, right? Third one is mediation. Now, why these areas are important? Simple logic is ADR means alternative dispute resolution. Why are they important? Basically, because courts are already very overburdened with number of cases, right? Basically, heaps of cases. And hence, when ADR comes into the system, when it is included in the system, it sort of reduces some burden from the judiciary. Also, mediation is something that will open new channel of dialogue between two parties, right? Suppose there are two parties who are not into a very good talking terms, right? In that case, mediation can be something which can channelize their dialogue in a very constructive way, and it can lead to some kind of solution about the problem, right? Now, this was the main purpose of mediation bill, wherein there was this freedom which was given to the party, wherein it was the provision mentions that one party can withdraw after 2 sessions of mediation, right? That's actually a very risky situation for the provision to put. Of course, it is going to be an experiment. We'll see how it works out. However, I guess it would work well. Simple, right? Two people got into mediation after two sessions. Suppose they feel that they won't be, they won't be able to come to any solution, and those dialogues, those talkings are not working. Of course, in that case, parties would decide that they should discontinue with mediation and go for the court procedure, right? So, this bill, the provision in the bill is giving such right to withdraw. That is one. Two is with respect to the time frame which has been set, and that is maximum of 180 days, which can be extended to more of 180 days, but of course, in certain conditions only, right? Not only that, it provides a good amount of time for negotiation between parties. So that is also a plus point. Second thing, which is very interesting here, is about Mediation Council of India, which is sought to be established through this bill, right? Not only that, so far mediation has always been considered to be a very informal way of resolving disputes. Through this bill, the provisions seek some kind of legal bindingness to mediation so that it can be enforced and it can be taken seriously by the parties and not just like a side dish, right? And not only that, in case of mediation, mediators would be given similar, similar stature or similar stance, powers, or something like that, as court. Yeah, just to give them some kind of credibility, uh, becomes important, right? That was the second legal update for the day. Next one is with respect to self-respect marriage under HMA, that is Hindu Marriage Act. And this has been in debate since quite a while now, and now Supreme Court gave affirmation to that. It gave a nod. So what is the self-respect marriage, right? So basically, under Section 7 of Hindu Marriage, 7A of Hindu Marriage Act, there are certain traditions which have been mentioned in the act, which has to be performed by both the parties along with the priest, right? The Hindu priest. And only when those traditional rituals are performed, then only it is given some legal recognition, right? And not only that, there is another thing which is very important with respect to HMA, to consider a marriage valid, and that is about the public, right? Whether it has been done in front of public, there has to be some people around when the marriage takes place, when the rituals take place, when the priest performs certain rituals, right? So that is what Section 7E mentions. Now, what has been done? So it actually comes from Tamil Nadu's government, wherein an amendment was done to simplify the wedding rituals and all of that, and hence the Tamil Nadu government eliminated the need of priest and all those Hindu rituals, which is quite traditional, right? So it was eliminated by the government, and later on it was taken up by the court, by the Supreme Court, wherein the Supreme Court simply said that public recognition should not be a prerequisite for a valid marriage. So even if there are two people want to get married, they can go get a marriage certificate. And even if there is no public recognition for them, they can be considered to be married. Yeah, even though they are not performing all the rituals, all the traditional rituals that are mentioned under Section 7A of HMA, even then, right? Even then, two people can be considered to be married, and that too in a valid way. And this is basically modernization of marriage in our country, right? Wherein self-respect marriage is given some kind of recognition, right? It is given some kind of recognition as an alternative to the traditional rituals that we have been following since years now. So that was an interesting case. Next one is with respect to the copyright infringement of religious text, in which Delhi High Court gave certain judgments. So let's see what it is about. So basically what happened, there is this publication, Bhakti Vedanta Book Trust, right? They uh, they print all the religious philosophies, right? And most famous or the bestseller, one of the most bestsellers was Srimad Bhagavad Gita, right? Now, uh, this trust, right? They accused a lot of online platforms on the internet to for copywriting their uh, Bhagavad Gita, which was written by Srila Prabhupada, right? So that was the a matter of concern here. Now, what is copyright? Very first thing that should be known, and I hope by now you would have read about copyright here and there. Copyright is very simple, right? Copyright means you give someone the right to copy. Means even that if anyone wants to copy, they will have to come and ask you. You are the one, you have the authority to give the right to copy to someone else. Now, to what, right? I'm giving right to anybody else, but how do I decide whether this is my work, right? Basically, it includes all the literary work. You write poem, you write some story or anything of that sort. There is something which is artistic, something musical, right? All of these, wherein certain art is required, all of those forms, right? If you bring up or if you come up with something which is very exclusive in the creative expression, which has not been expressed in such a way, right? It is not about the content, right? It is the way you express it. If you have come up with such kind of expression which has not been done by anyone before, which is completely exclusive and not a copy of anybody else, in that case, you have the copyright over that work of yours, right? And then you get the right to decide who will copy and who will not. And you may also decide that nobody is going to get a copy of this, right? You will be the one who will be deciding, who will be at the authority. Now, when that right is infringed, then we say copyright infringement issue, right? Now, there have been certain issues. Why this issue got so much of highlight is because when it comes to religious text, right, there are certain freedom which has been given with respect to its copyright, right? Why? There are several reasons, of course, to let our culture be known by people, let our art be known by people, let our heritage be known by people, and basically for that, from the cultural and artistic. So the court basically try to create a balance, maintain a balance between the special case of religious scriptures and the copyright, right? Because it was important for the court to maintain some balance, because there is some freedom of speech and expression on the other hand as well, right? Plus art and culture perspective that I just told you. Now, court simply said that when it comes to the religious scriptures, they fall under the public domain. And when such religious scriptures are translated or their creative adaptations are taken, then copyright protection can be considered in such cases. Of course, public domain में है religious scriptures, but जब उनका translation हो रहा है या फिर जब हम उनको creatively adapt कर रहे हैं किसी और form में, in that case, copyright protection को validity मिलेगी, right? That's what that was a very important uh, you know uh, thing about this complete judgment, because that is something that balances the entire debate which was going on since a really long time, right? Not only that, uh, certain rights were since they have such rights, all the unauthorized production of such copies of Srila Prabhupada was considered to fall under the copyright infringement, and hence accordingly penalty was also imposed, right? Because of course the translation, the creative adaptation, all of that requires some kind of creativity, and I just told you copyright is all about how do you express, how creatively do you express It need not always be, amazing or out of the world. It just needs to be exclusive. That's it, something which has not been done by anybody else, right? That's what copyright basically, uh, contains as its ingredients for the eligibility, right? So, yeah, that would be it for today's session, guys. If you have any question, please feel free to put it in the comment section below. And all the very best for the upcoming examination. We hardly have just few days left for the exam, and I'm sure you are high with your preparation and at your best. Thank you so much. Take very good care of yourself. I'll see you in the next session.